Hello, I'm Tamur Ahmad. Today I'm here to represent for the video presentation to assessment company law course 1, and my student ID is this, and my student number is 2102828329. Now I would like to start my presentation. So first of all, I introduce my topic and introduction of this my topic. A company is not only a different legal entity from its member, but it also its owner to manager, inventors, and any other stakeholder it may have. This is the due fact that the corporation or separate legal identity is as a direct consequence of this. It is the legally instant from these parties. As a consequence of this, it is entitled or the certain rights, and it's also obligated to fulfill a number of specified tasks and responsibilities. According to the concept of a limited liability, a company's owner are normally not answerable or liable for the company's debt. As a sequence of this, the shareholder of this company are only obligated to pay the amount of their unpaid shares and not the company's debts. Because the widespread adoption of the nation of the notions that the emerged from the Solomon's decision, it is now well established that the corporation possesses a distinct legal personalities distinct from the its investors. So first, uh, understanding the concept of the separate legal identity. Since ancient times, the idea that the corporation that had its only unique the legal being has been accepted by a number of court judgments since that the time the legal personality of the company when the instant of the separate legal entity has also been recognized. The trend continues into the 20th century as well. The change of the shareholders, structures, and the strengthening of the internal corporate connection are two examples of the advancement that they have been made in common law for over the course of the legal history. These help the process of separating of the company from the investors, which is turn help into the process of the separating partnership and the corporation. A legal entity is referred to as a legal person, which is another name of the person who is the organized by law. Legal rights and responsibility held by the corporation and the separate distinct from for the those held the individual who administer and or control the company. A separate entity can be defined by the following essential characteristics. It is authored to buy, sell, and hold any from the property in its own the name, and it may do so without the restriction. One should only enter to the contracts that can be upheld and bring the legal action in one's own name and defend them if necessary. For a legal point of view, separate legal entities and the considered of the assist of any and all the legal entities that the capable of performing activities then can be performed by the people or company operates as its own distinct legal entities after registering with the state. The company uses the records and the ownership of transactions of differentiate its operation from those of their of other business. The three main instance upon which is the corporate veil by the pierced by the rationale behind their usage. Misunderstanding the ambiguity both the contribute of the clouding of the meanings of the phrase through the corporate veil. Court are aware on the one end that the corporation from the design by the legal person with the characteristics of the personhood under law. This means the corporation can sue and can be sued in other on right. The courts are the aware that is order to exercise the equitable jurisdiction. They must be regulatory and the cautionary in the order to penetrate of the corporate veil. Other situations in which veil piercing can take place include. So number A, piercing the veil by the legislation in order to make the corporate actors behavior consistent with a certain statutory system such as the society security or state unemployment compensation. The programs penetrating the corporate veil is the first utilized as a weapon of the statutory interpretation when it's come to achieving this basic legal goal of the government benefits program, such as making of the distinction between the owners and the workers. For example, the corporate structure is often overlooked. This is done so that the program may successfully carry out its mission. Obviously, there are the instances in which adhering the corporate structure in order of manufacture of the product that satisfies the requirements of the certain set of the state and federal regulatory guidelines and the constitute an absolute need. So a variety of legal clauses restricted by the business independent legal status of the by putting the onus of completing the company task on the member of the company or in the most severe of the circumstances the director of the company according to the provision of the section 19(4) and the Finance Act. If any company competes or tax of offense with the permission of the company director and the individual in question may be liable to legal action. Number B, piercing of the veil by the courts. Second, piercing is something that courts do as well. It has been established that they have courts will not to let the veil encryption of the use of fraudulent purpose. They will not make an exceptions of the policy because the court have a lot of leeway determining whether or not to lift the corporate veil. It is the possible to come up with a single set of the guideline that applies everywhere. The veil have been lifted in the past of the consequences of the decisions brought about by the following situation. In the case of the Guilford Motor Company, we on in 1933, the chapter 1935. The defended the company both a constant or the non-compete provision of the event of that defendant decided the leave of the company in any effort of the circumvent the terms of the agreement that resigned from the position and properly established or the competing business in which his family would have honor position and in which he would serve of any employee. The certain was taken by the court. In 1962, Jones Lippon 1 all ER 442, the seller of the home was able to avoid being the subject of particular performance order against by him the selling of property of the business that he had already established, according to Russell J., who referred to the company as a make in the hold of different front of his face, an effort to elude detection by the eye of equality. The corruption corporation was described as an artifice of the end of phrase. The court lifted a veil of the witness, placing number C, placing on ground back repressive value. The third reason that we have the foundation of court place the corporate veil in the corporation of what we refer to established bankruptcy principle. The purpose of the law governs bankruptcy to ensure that the asset of the debtors and the liquidity the recognized in the manner that is the both quick of profitable. In the event of the legislative required take effect, the rule of the separate corporate identified could not be applicable for the for instance, fraudulent trading is considered criminal act according of section 213 of the Insolvency Act of 1986. Under the provisions of this article, directors and the other individual may be held liable for the obligation of the business if the activities of the companies have been carried out with the intention of the defrauding creditors. If a director of the shadow director know or should have the settled that there was not any realistic likelihood that the business would avoid going the insolvency at some point before the company went to liquidation, then they could be held liable for gross misconduct under section 214 of the Insolvency Act of 1986. The provision applies to both directors of the shadow directors. The idea of the complementary in the idea of the dishonest trading according to section 216 of the Insolvency Act in 1986. It is illegal for a director of the corporation that is known by a band name of use that name. The provision was added in 1886. And number two, how company law principles support the decision in the Solomon v. Solomon. Since judgment of Solomon v. Solomon and Co. Limited that the concept of corporation separate personally has been well established in common law, it asserts that a corporation possesses its own distinct legal personality as well as rights and duties are totally distinct from those of the shareholders. The case established a number of standards which were then utilized in cases that were comparable. The existence of the separate personality leads naturally of the development of some characteristics such as the liability of the corporate personality. To name a few, it is the corollary of the concept of the corporate personality. The ruling rendered by the House of Lords in the cases Solomon v. Solomon led directly the development of the liability protection of establishment of corporate identity as a robust legal framework in the in notwithstanding the overpowered number of attacks on those two ideas, which are generally acknowledged as the twin pillars on which contemporary company law is constructed in the court, have it overall have been prepared to defend and the support it. This is a deposit fact that there have been large number of such attacks. It is no common knowledge that is order to have for a business to constitute it, it must be first fulfill all the prerequisites outlined in the Companies Act 2006. When a company chooses to incorporate, it received the legal status of a separate artificial person in the eyes of the law, which is distinct from the company's investor. The following are some of the relevant legal implications that they occurred. Number A, perpetual succession and extents. The fact that the corporation exists of the distinct legal body from the individual owner of member is the characteristics of the corporation. Personally, that is the most fundamental as well as the one of the which all of the consequences originate. It is the considered conceivable for it have the privilege that the distinct from those of the people have. It is possible for it subject duties and distinct from those it that the have member. Because of this, it is possible have both these things, because if it is not have been sorry, it have been a human characteristics if not a natural person. It is a frequently referred to it as an artificial person because it is a process legal as a result of the company or corporation that is founded accordance the Companies Act is considered is a different entity from the people who constitute it. This make perfect sense when they consider that the individual who create the business of refer to corporates. Number B, limited liability due to the fact of the artificial person is a corporation immune to the caprices of the flesh. It is not to predator predetermined lifetime is the immune of the becoming sick of the developing any kind of the physical mental disability. It does not matter if members leave due to death, retirement, or any reason. The organization maintains interrupted succession of the extents as a consequence of this encryption ensure the operation of the company will continue when even when the passing of the uh, businessman single businessman is the construct of the situation contrast of the situation which is the passing of the single partner of partnership could result in the immediate dissolution of the partnership. Property, one of the most apparent advantages of the having the corporate personally is the capacity of the differentiate between the property of the organization and that is the individual member. The member of the incorporate society have equal rights to the association resources and that distribute them among themselves. Contract can be entered into by the company through the authorized personnel since the company can behave in the same manner of the any persons and the sequence of this it is had the ability to get benefits of the possession it is property. Makura with Northern Assurance rule the corporation has legal to title of its own assessment rather than its individual shareholder. The business does not hold any property in trust for its member and the member have no interest in the assets behind which is the intental of their membership of the company. Even if company biggest, the shareholder does not have the insurable ownership of the property. Number D, right to sue and be sued. Two keys the quality, they are the direct result concept of the legal entity, the liability of the business purpose, legal action of the susceptibility, the business of the legal action brought against it. The company has been the option of pursuing a legal action in order to save its reputation. To avoid any confusion, the company should always use the original name with the engaging of legal actions. By the action, in the manner we avoid to scenario in which the vast majority of unorganized organization resort of the extremely intricate technique of the representative action that they develop. As a result of the rule has been established is that according to what was said is the case of Force V and Horbot only the company itself is able to continue an action in relation to a wrong injury have been done. Number three, the inability of the court devise clear method to administrating the rule in the Solomon v. Suleiman is not a good 21st century corporate decision making. Generally speaking, the Suleiman judgment remained the cornerstone of the English corporation law. The key characteristics that is the cases let the indication the well preceding exceptions include shame, sake, facade, and fraud. Never themselves they are not. All includes in the lot of left of the discretion and interpreting of the courts by the case by case basis. More than a century after the scene, the Suleiman was Suleiman and Co. Limited was handed down. The markers and the court have identified a series of extraordinary cases in which judges may rightly dismiss a corporate district legal personality and the peers of the corporate veil, such as when fraud has been perpetrated when a business in the implicated of the wrongdoing for an example of the situation that cause of such action. In spite of this, the ascension principle that was established by the decision in Solomon was Solomon and Co. Limited is still in effect at the present day. According at the school of the thought, a limited liability company is a separate legal body that may exist to independently of the people who make the membership of its board of director. In addition, the concept that was presented in the Suleiman case can still be utilized in today corporate law. It is the possible to upgrade that the legal system will never make the exception of the let shareholder to be held accountable of the debts of the corruption uh, they own shares. This is the don't protect investor for the personal responsibility that may be incurred as a result to regulate line. In addition, they are going to pull off a certain they tell the reality, which is that the running as a firm would be harmful investors when deciding whether or not and any corruption status and benefit that the courts decide should be enjoyed. They will the occasionally but very rarely look at the content of the company rather than the form. For almost essentially, Solomon principle has been driving force in the development of business law and the law in the UK. As a direct consequence, the decision has been made it down by the Petrodel case in it is now abundantly clear that a judge will only ignore to dismiss the concept is particular circumstances. When the corporate structure underlies the conceal the truth, the court will frequently reaction a decision based only by the real facts of the case. This is the basic, and this is because the corporate structure notoriously difficult to circumvent. This decision may be made the basis well established legal notions such as agency, trusteeship. However, this does not be imply the court is looking behind the certain ignoring of overarching principle in any way. In the light of the fact that the application of such principles calls the presence for two more distinction person, the acknowledge of the concept of separate corporate personally is the instead requirement of this kind circumstance. Thank you so much for your time.